My lord, I beg to mention one item for hearing, lordship. He is an old man, lordship, in jail. So may I pray, lordship, that matter may be fixed, listed for on fifth, lordship, if possible, lordship.
No, the hearing matters on sleep not possible in December. You have to choose a date in January. You should have done it earlier. January we'll consider, but December, whatever is there in the list, we'll.
Whether it will become for orders for fixing the date for hearing.
What
lordship.
then you write orders? Orders. Orders you write.
May please. I beg to mention for listing one IML for suspension of sentence.
Next week. Next week.
Next week.
Please, before lordship, I pray before lordship for listing IA criminal tomorrow, my lord, because my lord, the accused person is under jail since 17/10/2023, and he's over 75 years old.
Monday, next Monday.
Yes.
Next Monday.
I must.
May I please, lordship? I beg to mention IA criminal, my lord. It was last listed on 1st of May, man. Can you come up on Thursday or Friday?
No, nothing, no listing will be allowed this week.
Kindly, my lord.
If you ask for this week, it will go to January. Next week.
Lordship, next week. Oblige, my lord.
I have also sent prayer, my lord. For IA, my lord. But must.
May I be, please, your lordship, I beg to mention item number 10. I request for adjournment for the same. I'm representing Advocate G. Chaudhary. He is actually out of station. His mother is critical and he is actually the sole caretaker.
What do you want?
Adjournment. Adjournment.
For how long?
For at least for the month of December.
A prayer for adjournment has been made in this case on behalf of Mr. G. Chaudhary, learned counsel for the respondent numbers 1 and 2, who is stated to be out of station for personal reasons. Since the prayer is made with the consent of learned APP Assam, Miss
Prerna.
Miss A. Begum, the same stands allowed. Let this matter be listed again in the month of January 2025. Yes. Item 10.
Daily list for admission, item 1. One to 5 jail appeal, lordship.
So, amicus curiae should.
Lordship.
1 to 5, we'll ask them to assign the brief to an amicus counsel and list the matter by showing the name. Same order dictate Lekho. This appeal is preferred from the jail. None has appeared for the appellant. In view of the above, we direct the registry to assign this brief to an amicus curiae from the panel prepared by this court and list the matter thereafter by showing the name of the learned amicus curiae in the cause list. Same order over 1 to 5.
Item 6.
This is the appeal under section 415 of the Bharatiya Nagarik Suraksha Sanhita. The convicting the impugned judgment dated 7/9/24, thereby passed by the Honorable Special Judge Ulalguri in the special POXO case number they have convicted the appellant for under 6 of the POXO for 20 years and 5 years under section 6 of the protection of his
So this is who is the respondent number 2? Informant.
informant. Yes.
Notice has to go to the
Lordship, please serve, lordship.
Admit code.
I'll share
But
it.
Mr. S. Islam, counsel appearing for the petitioner. With peruse the grounds taken in, not the petitioner, appellant. Peruse the grounds taken in appeal. This appeal is preferred against the judgment dated 7/9/2024 and order dated 17/9/2024 passed by the learned special judge Ulalguri in special POXO to bracket or case number 53 of 2023, whereby the sole appellant has been convicted under section 6 of the POCSO Act 2012 and sentenced to undergo rigorous imprisonment for 20 years and also to pay 20 years with default stipulation. And also to pay a fine with default stipulation. Full stop. Admit the appeal. Call for the records, issue notice returnable in 6 weeks. Since Ms. A. Begum, Learned APP Assam, has appeared and accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent. However, steps by registered post be ready for service of notice upon the informant stroke respondent number 2. Let the matter be listed after completion of service of notice.
Yes, IA also means.
After receiving the LCR, we will file lordship.
In the IA, had so and so, the prayer made in the IA shall be considered. This IA has been filed with a prayer to suspend the jail sentence of the applicant. The prayer made in the IA shall be considered after receipt of LCR. The state may file objection in the meantime, if so advised. Support did you IA filed under section so and so seeking suspension of jail sentence.
Item 10.
That is all. Well, this is a regular criminal appeal, my lord. Notice may be issued, man. 20 years for a POCSO.
So, it was ADD, Mr. A.M. Borbia. Baki order, judgment order. Judgment and order dated 1/10/2024. Passed in. Passed by Special Judge POCSO, Nagaon, Assam, in special case number 29 of 2015. Convicting the appellant under section 376 bracket 2 bracket Roman 1 bracket rules of the IPC and sentencing him to undergo rigorous imprisonment for 20 years and also to pay fine of rupees 10,000 with default stipulations. Number 2 informant. You have a IA?
Yes, only I.
Same order.
Obliged.
For orders, item 8. Paper will produce it, okay?
Paper book receiving notice.
Mr. One.
Lordship, it is listed for report for a report regarding service upon the informant lordship.
Formally.
Oh, whatever.
Oh. I would say
Kiba হৈছে? দিছে তো ন? পাটা দিছে।
it did style.
Except for any, they have received. My concern. So notice has been served.
Lordship.
Paper book I have received. Paper book received.
Miss B. Sharma and amicus curiae appearing for the appellate.
Mr. Kamaran.
Miss A. Begum,
Oh, I see.
APP Assam appearing for the state. The learned APP has produced a copy of the has received a copy of the communication dated 2/11/2024 addressed to the officer in charge of Khowang Police Station to submit that notice of this appeal along with copy of memorandum of appeal has been duly served upon the informant stroke respondent number 2 Prakash Bhumis through the officer in charge of the said police station, and therefore service of notice is complete in this appeal. After perusal of the aforesaid document, we are satisfied that the informant has been served in this case. However, none has appeared for the informant as such. Informant, full stop. Considering the fact that the conviction in this case is under the POCSO Act 2012, we deem it appropriate to engage a legal aid counsel so as to represent the informant in this case. Office to, therefore, assign this brief to a legal aid counsel from the panel prepared from the existing panel so as to represent the informant. Since paper book has already been prepared and furnished to the appellant's counsel, paper book be also furnished to the learned legal aid counsel. Learned counsel for the amicus curiae for the appellant as well as the learned APP. Paper book be also furnished to the legal aid counsel engaged on behalf of the informant respond number 2. Let the matter be listed again after 3 weeks.
Please, your lordship, my lord. Here it's also a case of under the POCSO Act, my lord.
Hmm.
Notices were issued, my lord, but I'm sorry, my lord, I could not see the office note. Last row. Huh?
As Jahane hai separately. Last day she was there.
One of them.
Abar dekhiye sir.
I go to communication dated so and so issued by the office of the learned additional public prosecutor Assam. What has happened?
Lordship, in this regard, Lordship, learned APP as Jahane was there, Lordship. So today, due to some inconvenience, he is not here, Lordship. So I'll have to get the information whether she have got the information or not. Lordship. A date may be fixed, Lordship.
Notice has been served. This one. We will treat it as served. Notice has been served. The acknowledgement is returned. Heard Mr. M. Deka, learned amicus curiae appearing for the appellant. Also heard Ms. A. Begum, learned APP Assam appearing for the state. Peruse the acknowledgement of the receipt of notice by the informant respondent number 2. Dated 17/10/2024, which is available in the record marked as capital Y within quotes capital Y. In view of the above, this appeal is deemed to be ready as regards service. However, since the conviction of the appellant is under the provisions of POCSO Act 2012, hence we deem it appropriate to engage a legal aid counsel so as to represent the informant in this case. None has appeared for the informant respond number 2. Full stop. Since the conviction is under so and so, registry to take necessary steps in the matter accordingly. List this case again after 3 weeks by reflecting the name of the legal aid counsel in the causal. In the meantime, copy of the paper book be furnished to the learned counsel for learned legal aid counsel to be engaged in this case.
That's 11.
May I appeal, your lordship? We have received the paper book, my lord. Informant is no more. Respondent number 2.
Informant is no more.
It is
Ah.
From where does one find it?
My lord, because informant is the mother of the accused.
Informant is the mother of the accused.
Yes, my lord.
It's all right. This conviction is under.
302.
All right, the informant is not a party. It's not necessary.
Lordship, not this. Only in,
So it's ready for hearing.
let the matter be fixed for hearing, Lordship.
All right. You right, heard Mr. S.K. Deori, learned counsel for the appellant, also heard Ms. A. Begum, learned APP Assam appearing for the state. This appeal has already been admitted and the matter is ready as regards service. Paper book has also been prepared and furnished to both the sides. In view of the above, let this appeal be listed for hearing in due course.
Apply.
Yeah.
Except in this case, we are filing the evidence today, Lordship. Let it be taken day after tomorrow or Friday.
You're filing?
The evidence, Lordship. There is an order on the last occasion, Lordship.
Mr. B. Chakravarti, learned counsel for the appellant, 1 week's further time to file.
Lordship, almost 10 years he is in jail. Taken up maybe Friday, Lordship.
No, it
I'm
will
filing
next
it
week.
today. Today
It will
itself.
next week. Pays for a week's time to file the evidence as per direction of this court. Ms. A. Begum, learned APP Assam is present and does not have any objection of the paper. In view of the above,
Lordship, may fix a date, Lordship.
let this matter be listed again in the next week as a fixed item by tagging the documents to be brought on record by the appellant's counsel.
Lordship, by the order dated 27/11/2024, learned counsel for the appellant directed to give a Lordship copy of the depositions to me as well as to my learned friend. Lordship, I have
Not
not
yet.
received as of now.
No, furnished. Financial account.
Yes, sir. Depositions.
Deposition. This is.
Deposition paisa?
Huh?
Deposition is it?
না ডিপোজিশন না হাকি বিলাক দেয়া হইছে আমি তো
You have this conference outside.
বি বর্মন
We'll adjourn
Lordship, I
it.
have not received it yet.
but we have furnished B Bormon has taken on behalf of Ms. Bhuya and she has taken so far
Let
regarding
me better taken up on some other day. I'll verify. I have no junior in the name of B. Bormon, my lord.
but my junior has given
We will fix the matter next
Yes,
week
yes.
to decide on the
Yes,
point
yes,
whether
yes.
copy has been served or not.
No, on the matter of,
We'll give a
I filed my IA, my lord, objection, my lord,
I
against the IA.
objection is there.
I filed my objection against the IA, but they were supposed to furnish the copy of the depositions. On some other date, your lordship.
What is happening? You sort it out in the bar. Why the court is being involved in this?
What's it written?
When the matter is called. up,
May it be
there is
tomorrow, my
some-
lord. I haven't been the bar since long, my lord.
Sorry?
Tomorrow it may be taken.
Bench is
Tomorrow.
not there. I
Okay,
don't
it's
think bench
possible.
is there.
Actually, I will, we have supplied, but so she has supplied, then I will take information and provide to both of my land friends
Day after tomorrow.
Day after tomorrow.
thereafter.
Ms. B. Bhuya, learned APP or some submits their copies.
So day after tomorrow, my lord, I have some
Positions
details.
as directed
be
by this
answered.
court by order dated 27/11/2024 has
the
not
big
been
one.
furnished to her. The said assertion has however been denied by Mr. M. Mahmood, learned counsel for the applicant.
My lord,
appellant.
may it be kindly fixed.
Be that as it may, in order to resolve the issue, a prayer has been made to fix this matter on 5th of December 2024. Prayer allowed, registry to list this case accordingly.
I'm like, file in, I know.
May I please, Your Lordship? Your Lordship, kindly the matter may be taken up after some time, Lordship.
Why it has been listed?
No, orders to हो कि करने ऑफिस में ऐसा नहीं कुछ पेपर बुक पैसा में हुआ को
Receive the paper book.
You are appearing for
Private respondent.
private respondent.
रेस्टोरेंट नंबर 2 डीपी মন্ডলর হয় নাকি এলা মজুমদার they paying for respond number 2 minor.
All right, take down this criminal appeal has already been submitted and the service of notice is also complete. Miss
B. Hazarika on behalf of
Yeah.
R. Chaudhary.
Ms. B. Hazarika has appeared for the appellant, whereas Ms. B. Bhuya, learned APP Assam, is present on behalf of the state. Stop. Your name? Mr. A. Thakuria, learned counsel for the respondent number 2, submits that he has not received the copy of the paper book. In view of the above, copy of the paper book be furnished to Mr. Thakuria within 2 weeks from today. Let the appeal be listed for hearing in due course by reflecting the name of learned counsel for both the sides. It will be listed for hearing.
Item 15.
May I please, Madam 389 application, my lord. Here what has happened, my lord? Charges were framed under section 306 and 498A, my lord. And without altering the charges, my lord, conviction was given under section 302. And medical evidence is, my lord, it's suicidal, my lord. No homicidal, my lord. And only 2-3 witnesses, my lord, murder. They suspect that it was a case of murder. No ocular witness, my lord. So can I seek 389, my lord? On the apparent, if I read the judgment, my lord, it would be apparent it cannot be done, my lord. It would never sustain, my lord. May just, with all respect, my lord. Lordship, may kindly have a look, my lord, with all respect, my lord, at page 17, para 5, my lord, of the judgment, my lord.
Judgment is annexed to?
Appeal, my lord. Memo of appeal, my lord, page 17, my lord.
Give the memo as well, please. No.
Memo of appeal. Page 17, my lord, with all respect, my lord, para 5, my lord. May I?
Yes.
After going through the case record and hearing the learned counsel for both sides, one of my learned predecessor framed charges under sections 498A oblique 306 IPC was against the accused person. When the contents of charges were read over and explained to the accused person, he pleaded not guilty and demanded to stand for trial, my lord. So charges were framed primarily, my lord, with all respect, my lord, cognate offenses, my lord, 498 and 306 IPC, my lord. Now, thereafter, conviction has been, my lord. Well, let me continue, my with all respect, my lord. May your lordship have a look at page 23, my lord. Doctor's evidence, my lord. There are injuries, my lord. There are injuries, my lord. If I begin from 22, there are injuries, no two ways about it, my lord. But, my lord, with all respect, my lord, the opinion is, my lord, page 23, para 16, my lord.
Yes.
He opined, may I, my lord?
Yes, please.
He opined that the death was due to asphyxia as a result of antemortem suicidal hanging. However, other injuries as ascribed were antemortem and caused by blunt force impact. So, my lord, it is suicidal, my lord. Whatever be the injuries, my lord, because of husband, wife, my lord, fracas, my lord, somebody may have committed, my lord.
Rope is exhibit?
Rope has not been found out, my lord.
So where did the doctor come to know about it?
Ligature mark, my lord. Non-continuous, my lord.
Ligature mark. Non-continuous.
Non-continuous
ligature
ligature,
method.
my lord. My lord, assuming, my lord, say, my lord, after committing suicide, I brought down the dead body, my lord. I may have, my lord, hidden that part. It will be 201, my lord. But 302, under no circumstances it can come, my lord. Possibly, my lord. And authorities, I need not place, my lord. They are appropriate tailor-made, my lord. Yeah, and it cannot be in a higher section, my lord. That is the, let's say, 223 is always minor section, my lord.
498, what is the maximum punishment?
3 years, my lord. 306, 10 years.
10 years.
Hearing like that, the LCR has been received.
No, lordship.
Yes.
Not else. It's a receiving.
Mr. Mahajan, we can give you a early hearing
If your lordship pleases, my lord.
because LCR has been received. We have to go through the evidence. Some analysis of evidence will be required. You may have an arguable point.
My
But,
lord. My lord, can I just have a try, my lord? If your lordship pleases, my lord.
no, what we are asking you is,
My lord.
we can either decide the IA
My lord.
today.
My lord.
It may go in your favor, it may go against
Yes,
you.
ma'am.
The matter ends there.
My lord.
Or we may consider the IA after a paper book is prepared. We can ask the register to expedite preparation of paper book. Which of the two options would you like? Because there are some points in your favor,
My
but
lord.
there are some points which are not in your
May
favor.
not be. My lordship is correct.
Therefore, we would like to just
Can I just place these two authorities thereafter, my lord, lordship, as your lordship pleases, my lord. These two authorities, my lord, with all respect, my lord, in such a given situation, my lord, with all respect, because charges were framed under section 498A and my lord, 306, my lord. My lord, of this authority, my lord, with all respect, my lord, 2022, my lord. Here, my lord, it occurs at page para 8, my lord. May I?
yes, please.
It is also needless to reiterate that for the purpose of proving the charge for the offense under section 302, the prosecution must establish homicidal death as a primary fact. In order to convict an accused under section 302, the court is required to first see as to whether the prosecution has proved the factum of homicidal death. Here, homicidal death is nowhere in ocular evidence, nor in the doctor's evidence, my lord.
No, that is not a impressive argument. See, the incident occurred inside the house
My lord.
when only the accused and the victim were there.
My lord, my lord.
Question of ocular evidence does not arise.
No, does not arise.
Number two, it is not a natural death.
Yes, my lord.
So it is a homicidal death.
My lord.
The evidence which you are relying upon
My lord.
itself shows that it is a homicidal death. Or there is a possibility that it's a homicidal death.
My lord, the points, the
only thing is the doctor's opinion.
My lord, two parts, my lord. I may be wrong, my lord, with all respect, my lord. The 10 points, 10 or 11, put below, my lord, with all respect, my lord. Primarily, it points to because he was having an affair with somebody, some other lady. Lady is also named. Even on the date of death, he was, my lord, talking to that lady. And apparent on face of the record, my lord, doctor's opinion and the points he made, and it must have led to 306, my lord. So far as conviction, my lord. So in that manner, my lord, when definitely, my lord, inside a room, it cannot be, my lord, ocular evidence cannot be there, my lord. With all respect and full reverence, my lord.
All right, now, Mr. Mahajan, what we wanted to ask you is,
Yes, my lord.
Since this is a first appellate court,
My lord.
By looking at the evidence,
my lord.
If the court finds that there are ingredients to convict under 306,
My lord.
Can we not do it? Can
Yes,
we not
yes.
convert it?
Yes.
Then?
Yes. No. That is why, my lord, as because, my lord, 302 has been given.
We'll tone it down to
No.
306.
Lordship is very correct. But provided, my lord, those circumstances arise, my lord. After hearing, my lord, with all respect, as your lordship is very correct, my lord. So at this stage, if I remain in jail, would it be of any use, my lord? Kindly, my lord. Tell him, otherwise I would have never, had it been a different case, I would have never prayed, my lord. It would be a case of suicide, maximum, my lord. But to be a case of suicide, the other parts, my lord, with all respect, my lord, as the law takes its own course, my lord, with all respect, my lord. Abatement 107
Abatement
IPC,
Could be there.
my lord.
Abatement could be there.
But no evidence to that effect, my lord.
How can be there evidence inside the, this burden comes under 106.
No, I have understood, my lord. Even 106 would be in what circumstances? In that event, my lord, whether, my lord, I should remain in jail, my lord. That only that part, my lord. As your lordship, kindly have a thought. And thereafter, as your lordship, I'll be very happy, my lord.
We would not like to answer it before the.
My lord, my lord, my lord.
We'll fix it on 9th of January. Ask the registry to prepare the paper book and
My lord, my lord,
furnish a copy.
my lord.
Right, I heard Mr. B.K. Mahajan, learned counsel appearing for the applicant, also heard Ms. A. Begum, learned APP Assam appearing for the state. UAPA?
N. Hassan, for respondent number 2, the
Ms.
informant.
L. Hassan, N. Hassan,
Legal aid counsel.
learned legal aid counsel is present on behalf of the respondent number 2. First up, this IA has been filed by invoking the jurisdiction of this court under section 389, bracket 2 of the CRPC, with a prayer to suspend the jail sentence of the applicant appellant. Mr. Mahajan has argued that the evidence in record is not sufficient to sustain the conviction under section 302 of the IPC. According to Mr. Mahajan, it is a clear case of suicide and therefore his client deserves to be released on bail. Full stop. We are of the view that appreciating such contention would require this court to have a primary glance at the evidence available on record, for which paper book would be necessary. Since the LCR has been received, we direct the registry to expedite the process of preparation of paper book. This IA be listed again on 9th of January 2025, along with the paper book. Copies whereof furnished to the council for the parties in advance. We'll consider it on that day. Because this will be the final judgment.
My lord, my lord, my lord, my lord.
Judgment in the IA will be the final judgment.
My lord, my lord.
Let us
Lordship,
have-
we will file objection in between.
You file your objection.
Lordship, for that.
See, there are two issues. One, the charge has not been
altered
so charge framed for a lower offense.
and
he has been
filed for a
convicted.
higher offense.
That is a problem area.
That is good.
But at the same time, this court has the jurisdiction to award conviction
Lordship.
by looking at the evidence.
Lordship.
Can it be done for 306 or 302? That
Lordship.
you have to argue.
Lordship.
And once both of you argue, we can give our answer after going through the evidence.
Lordship.
That is the problem here.
Lordship.
Mr. Mahajan,
Mal-
your client has.
My lord, highly obliged, my lord. Obliged, my lord.
May it please here.
Yeah.
Lordship, this is a regular appeal. A mistake has crept in on order dated 19/6/24, Lordship. That day it was admitted, and Lordship at para 5, it was written office to appoint Miss Rita Das Majumdar for the panel of amicus curiae to represent the accused appellant. The amicus curiae so appointed be furnished with the case paper. I was given, but actually it is a regular appeal, so Lordship, I think this is to be corrected and my name is to be deleted.
You are appearing for the.
I'm appealing for the appeal.
Okay, so this is otherwise ready.
The LCR has received, my lord, the paper book is not prepared.
Maybe the bench wanted you to be there as additional reinforcement.
No,
Even
the
I don't mind
accused appellant are in very good hands, Lordship, so.
No.
I'm for the informant. Respondent 2.
All right. Had Mr. B. Kaushik, learned counsel for the appellant, also had Ms. A. Begum, learned APP Assam appearing for the state. Mr. Aslam Khan has appeared for the respondent number 2. This appeal has already been admitted and the parties are also served. Paper book you have received?
No one.
However, the
LCR
paper
has
book
been
is yet to be prepared. It appears that LCR has also been received. As such, registry to expedite the process of preparation of paper book, full stop. Since this is a regular appeal wherein the appellant is represented by his engaged counsel on the request of Ms. R.D. Majumdar, learned amicus curiae, she is hereby disengaged from this matter. Office to delete the name of Ms. R.D. Majumdar from the cause list. First up, the order dated 19/6/2024 stands modified to the above extent.
Highly obliged, Lordship.
Fixing a date, my lord, somewhere
Objection file is in.
January, my lord.
List again in the first week of February.
I will file objection now.
Objection file one.
Your Honor, I will,
Objection.
I will file objection.
In the
maintain.
meantime, the respondents may file objection.
Grateful.
Item 17 and 18.
Wait, please, sir.
Yes.
Lordship, I mean, item number 18, my lord.
Hmm.
My lord, here there is an IA for bail, my lord. Suspension of sentence.
Lordship, analogously, one more item is there, Lordship.
Hmm.
And I was to file objection, but I have not received the petition copy from the learned friend, Lordship. So I am unable to file the objection regarding.
Not given a
the-
copy.
No, not in my matter, my lord. I mean,
But
item
it's
number 18.
Two
The
matters
connected
together,
matter,
Lordship.
my lord. Item number 17.
Why these are tagged together?
Because this is the same case, there are
Same
two
case,
accused.
Two accused, Lordship.
Now, who is appearing for item 17? The council is not even present. If the council is not present in 17, why should he suffer in 18?
Lordship, as Lordship is,
Hmm?
as Lordship thinks,
Same section, both of them.
Lordship,
ma'am.
same.
Who is Mr. J. Burman?
No, sir.
J. Burman, one of the answers the last time.
Junior.
People. Hmm?
Junior.
Kumar Junior.
No, no.
Do you know who is Mr. J. Burman?
No, no, my lord.
You don't know?
No, my lord.
Oh. He's your friend and you don't know. So tell us what to do. Why should he suffer?
Lordship, as Lordship thing is appropriate, Lordship. Because it is given as it is in the cause list, Lordship. So I am saying that last week, last week, Lordship, I was to furnish the copy, but he have not furnished to me.
Okay, let us.
And last date also, he have taken adjournment. Yeah, last date. Yeah, he can-
This is 17.
Adjournment.
Actually, in item 17 order also, your name has been reflected.
Item 17. No, my lord, I'm only.
IA
Item-
criminal 1024 of 2024.
Lordship,
The order said heard Sri DK Medi.
Kumar Junior Legu sir bhai.
I mean, item number 18, my lord. IA 1180/23, my lord.
Last week adjournment নিছিলে নহয় বুজি পাইছো তাৰ এটাতে দেখাই show কৰিছিলাম
What we'll do is we'll fix it on Friday because
Lordship.
there's apparently some error in the order.
Lordship,
And if the other party does not come,
Lordship.
then we'll detach it,
Okay, Lord.
take up your case and make it clear that
Separate.
this will be independently considered.
Lordship, Lordship,
We'll have no bearing.
Lordship.
In item 17, you write, none has appeared for the applicant when the matter is called up. Ms. A. Begum, learned APP Assam, has pointed out that this matter is analogous. This matter has been tagged along with item 18 of case number 2 Dibo. But item 18 should be taken up together. However, copy of the IA has not yet been furnished to her in connection with item 17. Apni case or number kira dibo hun. Under the circumstances, she has been prevented from filing objection.
Lordship.
First of Mr. DK Medi, learned counsel appearing for item number 18, on the other hand, submits that he has instructions to press this IA seeking release of his client on bail. And since there is urgency in the matter, this IA should be taken up separately, full stop. After hearing the submissions of learned counsel for both the sides, we direct the registry to list these matters again on 6/12/2024 as fixed item, so as to give one last opportunity to the counsel for the applicant in item 17 to do the needful. It is made clear that if the counsel for the applicant in item 17 remains absent without steps, even on the next date, these matters will be untagged and taken up individually in accordance with law. Let these cases be listed accordingly.
May I please, Lordship? Lordship, this I is for condonation of delay. Delay of 6 days, Lordship.
Delay of 6 days, we'll condone it.
Lordship.
Delay in 6 days of 6 days in filing a jail appeal.
Lordship.
All right, so condone koi do, condone koi do too. Hard miss. Huh? So, 6 days delay. Hard miss D. Borpujari, learned counsel for the applicant. Learned amicus, you are appearing.
Legal aid
Learned legal aid counsel appearing for the applicant. Also heard Miss E. Begum, learned APP Assam appearing for the state. This IA has been filed under Section 5 of the Limitations Act 1963 with a prayer to condone the delay of 6 days in filing the connected appeal. Stop. We have perused the explanation furnished in the application. Full stop. Considering the fact that this appeal has been filed from jail and in view of the fact that preferring an appeal against the conviction, judgment and order of conviction is a statutory right of the applicant. We are of the view that although the conviction of the applicant is under POCSO Act,
Lordship, he was convicted under 376 AB.
and under Section 376 A
AB of IPC.
of the IPC, yet keeping this matter pending merely for service of notice upon the informant would be a meaningless exercise. More so in view of the explanation furnished in the application. As such, by invoking our inherent jurisdiction and in view of the and for the ends of justice, we deem it appropriate to condone the delay of 6 days in preferring the connected appeal. Office to register the appeal and list for admission. I stands disposed of accordingly.
Lordship.
Please, Your Lordship. Lordship, the IA is for suspension of the judgment of.
Date of occurrence was 1988. And in fact, my lord, this was, my lord, judgment delivered on 1997. Last 36 years, my lord. And where I am submitting. And here in the case, my lord, there, although there are 12 witnesses were examined, PW5 is the eyewitness. PW5, your lordship will find page 17. Page 17.
What is, let us read the FIR once.
My lord.
Ajahar.
FIR page 4, my lord. Page 4, my lord. Humble submission is that at about 1:45 PM today, that is on 10/5/2088, Sri Ganesh Tati, son of Sri Suram Tati Sone, having let my mother-in-law in Chijiten Soika with a sub down continually. Here with 2 days.
Is it 88 or 98? 10-5?
88.
10-5, incident occurred in 88.
88. Accused and obliged. So that is the offer, my lord. And in fact, the learned trial court, my lord, on the heavily relied on the confessional statement and evidence of PW5. But on merit, my lord, your lordship kindly see the PW5 who is the eyewitness. But he was, my lord, the eyewitness was declined to cross-examine by the prosecution and by the defense, my lord. So that remain intact. PW5. But I am not on that now. I am in a very different footing, my lord. 313. The 313, here in this case, my lord, absolutely, my lord, that is only 2 questions, my lord. The lordship kindly see.
37.
Page 37, my lord. Page 37, my lord.
What is the testimony of PW5? Where is it?
PW5, your lordship will find page 17, my lord. Page 17.
Yes.
I know the accused in the dock. On 10/5/2088, I was working as a security guard in CCI, Cement Corporation of India. On that day, while I came to attend the duty of the factory with my motorbike, I saw Ganesh Tati work under CCI, cutting with a down another worker of the CCI, Jiten Tati on the neck, and the victim fell down the road and his bicycle. I then recognized both the accused and the victim. The accused on the dock of is the person who gave the dow blow on the victim. I raised halla, hard, each gets hold of the accused while he ran away, waving the dow on the air, shouting that he had to another person. Revenge to another person. Accused then boarded in a rickshaw and prostituted as Bokazan police station, surrounded the police. Lost declined. But even that question also not specifically put to in 313, madam. If your lordship see that 313, that question also not that whether the incriminating material, my lord, collected against him, that was not even directly put to him.
And where is the confession?
My lord, confession, my lord, yes, confession, your lordship kindly see. Page 63, my lord.
17th of session.
Confession statement, my lord.
70.
Page 70.
Page 70.
70. Your 11 portion you are to go to my lord. Page 70, yes. Page 70, my lord.
Yes.
Yes. I used to work in CCI packaging plant under the government of contract since 1979. December, November, at the time of government contract was Namesh Chandra Takil Lal. Then another contact of Sri Sandeshwar Singh Okajan took over the contact work and I started working under him with losing my work. Again, another contact was Ibubon Sharma of Bokajan got the contacts of Ibubon Sharma had made an agreement with us to pay wages of rupees 22 per day, and we paid accordingly for 8 hours daily labor. However, the contact was very irregular in paying our wages. At the time, we used to pay after 3 months only. Then it is in the year 1986-87 restored to strike, demanding various facilities from the company like uniform bicycle allowance wages as per law. When we resorted to strike, the work of BBCI packaging plant stopped. Then 2-3 days were summoned 60 labor to Bokajan PS by the OC Bharali. There was a committee to OC to withdraw the strike and rejoin our work. The OC had also obtained a signature to the fact that while in rejoining our work, after that we had gone to the rejoin our work, but we were not allowed to go inside the plant, and contractor labor brought new laborers from the Dimapur. Since then, we were jobless. This year, the old contract is Tikha Lal got back in this contact with the packaging plant. See, Tiken Lal re-employed some of the old labor but refused to take about 25 of us, saying management has objection against us. She Jiten Soikia, chief supervisor of after, used to tell us that he will take care of to see that what we do not get back our job, and that will set you right. I was angry against him for quite some time. On 10/5/2088, Tuesday around 1:45 p.m., I was standing in the shed below the CCI over the bridge with a dhow. I had came out from my home at 1 p.m. We were intending to doing daily work in the social forestry now in progress in the roadside. Some of my friends were already working in the afternoon hour. I was waiting to join them, knowing that they are likely to come that side. Suddenly, I saw the Jiten Soikia coming to by bicycle from his duties. On seeing him, I suddenly got engaged because of the anger I had against him for any condition of my colleague condition that is not mean with a doubt. As I strike the first blow, Jiten Soikia fell down from the bicycle. Then I gave him a few more blows to finish him off. After that, I went to the surrender in the Bokajan police station, Thana, along with Dow. Some people had started huge and cry and said, catch him, but I said none of they came on near to us. I have killed him, and I am proceeding to the Thana to surrender the man who he died on the first blow of itself. I gave him few more blows. I hold this responsible of my petition. But that is but my lord, if your lordship, PW12, lordship kindly see PW12, my lord. My lord, PW12, your lordship kindly see at page 34, my lord. While recording, my lord, the confessional statement, but one line that your lordship kindly see, I have to see the original record.
The confessional statement was recorded by executive magistrate.
My lord. No, at that point, probably that point of time not is not separated. That's it. That is in Bokajan. No, my lord, one line and confused me.
It says Diffu court. At that time, it was executive and judiciary was not separate.
Not separated in 88. 88 not separated. No, whether it is, my lord, the last part, page 35, my lord, one line, that is, my lord, disturb me. I have to go to the record, my lord. 2 police officers were allowed to stay in room while recording the statement. If it is whether it is correct or not, my lord, that line, my lord, I have to see the court, my lord. If it is like, my lord, 2 police officers is there, my lord, that cannot be, my lord, is a confessional statement, my lord. But কি লিখা আছে? 92
Deposition of negi hot.
main to sir.
No, deposition.
PW 12
Oh,
কি হচ্ছে নাকি? PW 12
deposition 23 to 14. PW.
Accordingly, the accused was produced before me at 11:40 AM for recording his confessional statement. Police officer was allowed to stay.
No police officer was.
Yes, my lord. But
Additional listen, no?
Hmm?
Kutu line na? Gonestante came.
to hold on. DK
Etu. SP.
Gokul Mohan Hazarika.
PW
12.
12.
10.
10, 11, 12. Kutu.
Accordingly on 12.
5, the accused
Produced
produced before me at 11:40 AM.
The statement of EW
JBO police officer was allowed to stand in my room.
Is it no or JBO?
Oh, no. No police officers allowed to stand in my room.
Not stand, stay.
Oh, yes, stand.
Stay.
Oh, stay. I'm sorry.
Is it no?
Yes, maybe no.
Maybe. It's not clear, my lord. If it is no, my lord, then I have no case. And that's my confessional statement is, my lord, correctly recorded. But if it is two police officers were or my lord JVO, that's just JVO.
No way.
No. So then, my lord, that confessional statement, then only my lord 313, my lord, because
313, there
At
is
least
an
one
eyewitness
question,
and then you have confessed what will happen next
that,
year.
my lord, I cannot impose. When my lord PW 5, my lord, the main eyewitness was not cross-examined, my lord.
Then what can be done?
It is very difficult, my lord. But in 313, my lord, your lordship can see only 2 questions, my lord. Why?
No, it's not correct.
They're not correct, my lord. That's why I'm saying not correct.
It's not correct.
Very, your lordship, can evidence says against you. But specifically, he has to say that evidence PW 7 and PW 5, because 7 is not a
Correct.
eyewitness.
But then see, what will he say in 313? Because he did not cross-examine the eyewitness.
Exactly, my lord. I cannot improve now, my lord.
He cannot even say no. He cannot even deny
No,
the
that
dispute.
first line is the corroborating, my lord, that yes, it is true, I appeared before the Thana with a doubt. That is in confess 313 also.
That he has said.
That is there, my lord.
Which page is 313?
313, my lord, your lordship will find next page, 37, my lord. 37. First question, your lordship kindly. Please, 37 page, my lord. It is alleged in evidence against you that about 1:45 PM on 10/5/1988, you intentionally hacked to death Sri Jiten Saikia, an employee of the Bokazan CCI, which is now near hospital Tiniali, while he was on his way to office, that you appeared and PS with a Dow in your hand after the incident. What is your reply in this regard? I did not commit any offense. It is true that I appeared before the PS with a Dow. Second question. When you were arrested, a connection with the case and produced before the magistrate, you voluntarily confess your offense. What is your reply in this regard? I did not confess voluntarily. I made the confession out of fear of the police. Only that 2 questions, my lord.
Where is the judgment on 313?
313, my lord, your lordship judgment, my lord, that is very clearly discuss everything up to 2022, my lord. That is judgment was passed by your lordship in my lord. That is Gobind Singh, 2022 2 ZLT 790. And in that case, my lord, regarding 313 in para 46, my lord.
Then Rina Hazarika's husband also there, man.
Can you give the citation of Gobind Singh?
Gobind Singh, my lord, that is 2022 2 ZLT 790. And that is the judgment, my lord. In this case, my lord, up to 22, my lord, all the judgments were discussed. After that, my lord, two other judgment in 2024 and 22, my, one is, my lord, yes, 24 and 23. There are two other judgments passed by the apex court, one in the same line. But in that two cases, my lord, because of the, my lord, delay, in that case, my lord, already person was in jail for more than 12 years, more than 10 years. That's why, my lord, it acquitted. So I just, after this, Gobind Singh case, my lord,
Gobind Singhal,
Gobind,
lordship
sorry,
judgment.
Gobind Singhal, my lord, that was remanded back, and for that stage, it will be started against only one accused, not all.
What happened to the trial?
Lordship rule is going on.
And this Gobind Singhal judgment is it still stands. There's
Still
no-
stand. I still stand the same view, my lord. It is still going on. But only these two judgments, I have to be pointed out that in 23 and 25, 24, two judgments passed by the apex court regarding delay, that was been acquitted. But others, that confessional statement.
All right. See, Mr.
Sorry,
Mahanta,
my lord.
we would request you to argue if you want to. There are two aspects here, as we have understood. See, the whole idea of 313 statement is to give the accused a chance to explain.
My lord.
With regard to the incriminating material which are collected against him. So, what are the two key incriminating material against him?
My lord.
First is the evidence of PW5.
My lord.
PW5 is an eyewitness. He stated that he has seen. And as you have mentioned, he has not been cross-examined.
No, there is.
So his evidence stays intact. So now the accused cannot even say that I don't agree with this view. He cannot say. So even if a question was put to him, he could not have given an answer to protect himself or shield himself from the testimony of PW5. Secondly, insofar as the confessional statement is concerned, though he said that it was under duress, but the evidence of the magistrate who recorded it clearly shows that the procedure was followed.
Procedure followed. If it is
Therefore,
followed, procedure.
and rest of the materials
Are
will be irrelevant, will be relegated.
So that,
to
my lord, your lordship put me a question, how I am pleased with this? How I am pleased with this? My lord, only, my lord, that if, my lord, PW5 was cross-examined, then I have a extra list.
Then the matter would have been different.
But now, my lord, even with, specifically the PW5 does not put to me, my lord, correct? That is absolutely correct. Even it was put, my lord, and I cannot explain because it is not cross-examined. In that way, my lord.
It would have been a mere formality.
Mere formality.
No question of prejudice. So,
that is the case, my lord, I cannot improve. I've seen, my lord, except 313.
and other witnesses are there.
Other witness, only eyewitness.
Eyewitnesses, according to me, there are two more.
Who are those?
Lordship,
Seven.
seven and 10. Saw the effect, PW10.
7 and?
7, 10, my lord.
So it is life imprisonment.
Life.
Not life till death. How many years
No,
has been in jail?
He's in jail for last 7 years, my lord.
Lordship, and one more thing, 10/5/88 date of incident. And your 313 was recorded on 23/3/97. 97, your lordship.
313 recorded in 96.
That's all right.
Yes.
See, 313 has a purpose.
Yes.
So the courts have been very clear that it's a very important right
Lordship.
which cannot be denied.
My lord.
But there is a question of prejudice which will always be tested on the facts of the case.
My lord.
Prejudice can't operate in thin air.
My lord.
So as Mr. Mohanta has also very eruditely, I would
No.
say, and very rightly pointed out, that had the defense cross-examined and made suggestions that you have not seen,
My lord.
then the court would have probably had no option but to.
Lordship.
But he did not challenge he
My
did
lord.
not assail the evidence.
My lord.
And that evidence, if there is eyewitness, everything else pales into insignificance. That's the. So we'll pass the order.
Keep your blame.
Yes, next matter.
See,
21.
Please, Lordship, kindly may allow for time being, Lordship. My senior is lag on in Court number 13, Lordship.
All right.
Item 22.
He's on the way.
Why to correct? Oximeter live streaming be stopped.
Yes. Yes,
Better.
Mr. Kama.
Malat, I'm in the long incarceration for the last 10 years, 12 years as of date, my lord. And
12
on
years you are in?
jail, my lord. And there was no delay from my side for the ongoing trial, my lord. As of now, my lord, only 117 PWs has been examined on today out of 288 PW. So 172 PW still left, my lord, to be examined, my lord.
This is the first time you are seeking bail.
Yes, my lord. In the High Court, my lord. In
So
the High
last
Court.
10 years, you have not applied for bail
No,
earlier.
my lord, no, my lord. Because the Honorable Trial Court, my lord, when we pointed out this long interrogation period, my lord, the Honorable Trial Court was of the view, my lord, that we don't have that power to grant bail for long interrogation. It is only the Constitutional Court which can grant bail on that consideration, which probably is not a correct proposition, my lord. That your lordship will find, my lord.
It's 108.
At page 108, para 10, my lord.
Yes.
His wife was granted bail by this honorable court itself, my lord, after 5 years. His wife was also taken into custody, my lord. Para 10, my lord, I'm reading it from page 108, my lord, serial page. It has been held in the case of Union of India versus K.A. Najib, reported in such, and Tuha Fasil versus Union of India criminal appeal as such, that Constitutional Court, by invoking Article 21 of the Constitution of India, can grant bail to the UTPs in appropriate cases, especially those who had spent significant time in under trial detention, and that this would be so despite the existence of the statutory bars under Section 43D(2)(5) proviso UAPA. However, such powers are not available to court like the present one, so as to consider grant of bail on other humanitarian factors projected by the Defense Counsel in the instant bail petition. So now in the meantime, 2 more landmark judgments has also come, my lord. 2 more landmark
So
judgments.
other judgments have also come.
Yes, my lord. In between, my lord.
Which says what?
My lord, it says, my lord, that this distinguishing features has been done, my lord, in the case of Sheikh Javed Iqbal versus Asif in answering, my lord. 2 copies I'm giving with the citation, my lord, though we have taken it from Manupatra.
No. No?
Sheikh Javed Iqbal versus Asif Ansari. Citation to me likhna po. Photo citation to Sheikh Javed Iqbal versus. Actually, in between another Supreme Court judgment was there. In that case, my lord, it was distinguished, my lord. This Gurvinder Singh, my lord. That how those cases were decided earlier. Then by this case, Honorable Supreme Court distinguished against this, my lord. In between 2 judgment has come.
So, Mr. Kama, you are saying that this conclusion that the court below did not have the power to grant bail,
yes,
is erroneous.
My lord, to an
Correct.
extent, my lord, absolutely.
So if you succeed in convincing this court, then we will set aside this and ask him to consider your application afresh.
That can be done, my lord.
Correct.
In view of this now new judgments, my lord, Sheikh Javed.
We can lay down a time frame to decide the matter.
Yes.
Because the court below has not applied its mind on your.
Yes, yes, correct, my lord. And another,
And what do you have to say, Mr. Chaudhary?
So far as Lordship, the delay part is concerned, Lordship, law was well settled in K and achieved Lordship that when it is a long period of delay, then they can be released on bail by a,
correct, my lord.
in the judgment it says by a constitutional court. K and Najib says by a constitutional court. Therefore, the learned trial court has reiterated that by a constitutional court. But then again, in the case of Gurvinder Singh, if I may refer to paragraph 32.
Paragraph?
Paragraph 32.
I have given my.
Yes.
I don't know whether it will match with my lord's, that's. I've got a different, I'll just start, Lordship.
Yes.
The appellant's counsel has relied upon the case of K. Najib to back its contention that the appellant has been in jail for last 5 years, which is contrary to law laid down in the said case. While this argument may appear compelling at the first glance, it lacks depth and substance. In K. Najib's case, this court was confronted with a circumstance wherein, except the
No,
response.
we are not getting the paragraph. Which?
It is, Lordship. So third paragraph from the end, Lordship. No, it's from Supreme today. It's towards the end, Lordship. I will just.
Yes, okay. We have got it.
Yes,
Page
Lordship.
44, paragraph.
Yes, Lordship.
Please read again.
The appellant's counsel has relied upon the case of K. Najib to back its contention that the appellant has been in jail for last 5 years, which is contrary to law laid down in that case, in the said case. While this argument may appear compelling at first glance, it lacks depth and substance. In K. Najib's case, this court was confronted with a circumstance wherein, except the respondent accused, other co-accused had already undergone trial and were sentenced to imprisonment of not exceeding 8 years. Therefore, this court's decision to consider bail was grounded in the anticipation of the impending sentence that the respondent accused might face upon conviction. And since the respondent accused had already served portion of the maximum imprisonment, that is more than 5 years, this court took it as a factor influencing its assessment to grant bail. Further, in K. Najib's case, the trial of the respondent accused was severed from the other co-accused owing to his absconding, and he was traced back in 2015 and was being separately tried thereafter. And the NIF had filed a long list of witnesses that were left to be examined with reference to the said accused. Therefore, this court was of the view of unlikelihood of completion of trial in near future. However, in the present case, the trial is already underway and 22 witnesses, including protected witnesses, have been examined. As already discussed, the material available on record indicates the involvement of the appellant in furtherance of terrorist activities backed by members of banned terrorist organization involving exchange of large quantum of money through different channels which need to be deciphered. And therefore, in such a scenario, if the appellant is released on bail, there is every likelihood that he will influence the key witnesses of the case, which might hamper the process of justice. Therefore, mere delay in trial pertaining to grave offenses as one involved in the instant case cannot be used as a ground to grant bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted.
So, Mr. Kamar, this judgment, how does it help you?
Yes, my lord. Now, your lordship, after 5 months, my lord, another judgment has come wherein the.
No, first, let us finish up with Gurinder Singh.
Yes, my lord.
You are relying upon this judgment, is it?
Yes, my lord. I'm placing the truth before your lordship, the legal proposition as of now, my lord. But I am heavily relying on K.A. Najib and also the last one, that is Sheikh Javed Iqbal, my lord. And he is relying on Gurbinder, my lord. But to be fair to the court, my lord, I have placed all the judgments. my lord.
Okay.
Now, after 5 months of this Gurbinder, my lord, again, the Honorable Supreme Court has the occasion to scrutinize the matter, my lord. Then the Honorable Supreme Court, presided by two judge bench, my lord, says what your lordship will now see in para 32, my lord. How the Gurvinder Singh is now been distinguished.
Para 32 of
Yes.
Javed.
The
Javed
para
is-
32 of the Javed of Sheikh Javed Iqbal, my lord.
Yes.
I read for your lordship. Can you, let us go from para 31, my lord. I think that will be more convenient. In Gurvinder Singh Supra, on which reliance has been placed by the respondent, a two-judge bench of this court distinguished K. A. Najib Supra, holding that the appellant K. A. Najib was in custody for 5 years and that the trial of the appellant in that case was severed from the other co-accused, whose trial has concluded. Therein, my lord, the trial of the other case, K. A. Najib's case, was progressing. Subsequently, this person was arrested during that period of time, my lord. So in this context, the Honorable Supreme Court is now saying that the other co-accused whose trial has concluded, whereupon they were sentenced to imprisonment for 8 years. But in Gurvinder Singh, the trial was already underway, like our case. And then 22 witnesses, including the protected witness, have been examined. It was in the context of the two judge bench of discourse in Gurvinder Singh observed that mere delay in trial pertaining to grave offense cannot be used as a ground to grant bail. The court has time and again emphasized that right to life and personal liberty enshrined under Article 21 of the Constitution is overreaching and sacrosanct. A constitutional court cannot be restrained from granting bail to an accused on account of restrictive statutory provision in a penal statute if it finds that the right of the accused of under trial under Article 21 of the Constitution has been infringed. In that event, such statutory restriction would not come in the way. Even in the case of interpretation of a penal statute, howsoever stringent it may be, a constitutional court has to lean in favor of the constitutionalism and the rule of law of which liberty is an intrinsic part. In the given facts of a particular case, a constitutional court may decline to grant bail. But it would be wrong to say that under a particular statute bail cannot be granted. It would run counter to the very grain of our constitutional jurisprudence. In any view of the matter, K. A. Najib has been rendered by a three-judge bench, which is binding on a bench of two judges like us. Gurvinder Singh was also pronounced by two judges. Thus, having regard to the discussion made above, we are of the considered view that the continued incarceration of the appellant cannot be justified. We are therefore inclined to grant bail to the accused appellant. Consequently, we pass the following orders.
And where is Najib?
My lord, Najib is a three-judge. Ma'am. This was passed by a three-judge bench, my lord.
Yes.
Herein other judgments which I would have relied otherwise, K. N. Najib has also discussed those judgments. That is like Angela Harish Sonkar. That was only for a few months, my lord. She was granted the bail, my lord, in a UAPA case, wherein 200 witnesses were to be examined after 4 years, sorry. So all the judgments of the earlier.
Which is the relevant paragraph?
Yeah, my lord. It starts from para 13 May, if your lordship look.
Para 30.
Yeah, 1-3, my lord. But basically it will start from 10, my lord. 43 D5 is there, my lord. Shall I read, my lord?
Yes, please.
High Court's power is also discussed at para 10, my lord. It is a fact that the High Court in the instant case has not determined the likelihood of the respondent being guilty or not, or whether rigors.
UAPA Act.
Yes. Whether rigors of section 43 D5 of the UAPA are aligned to him. The High Court instead appears to have exercised its power to grant bail owing to the long period of incarceration and unlikelihood of the trial being completed anytime in the near future. The reason assigned by the High Court are apparently traceable back to Article 21 of the Constitution, of course, without addressing the statutory embargo created by section 43 D5 of the UAPA. The High Court's view draws support from a batch of decisions of this court, including Shaheen Welfare Association, laying down that gross delay in disposal of such case would justify the invocation of Article 21 of the Constitution and consequently necessity to release the under trial on bail. It would be useful to quote the following observation from the cited case. So this were quoted. Next para 12. Of the same judgment, my lord, Shaheen Welfare. Even in case of special legislation like the terrorist and disruptive activities, Tada Mala earlier, and narcotic, drug and psychotropic, wish to have somewhat rigorous condition for grant of bail. This court in Paramjit Singh versus State of Delhi, Babba versus Maharashtra, Umar Mia versus State of Gujarat, unless the accused on bail, they have been in jail for an extended period of time and little possibility of early completion of the trial. The constitutionality of the harsh condition of bail in such special enactment has thus primarily justified on the touchstone of speedy trial to ensure the protection of innocent civilians. We may also refer to the orders alleging similarly situated accused persons under the UAPA Act passed by this court in Angela Harris Solanke versus State of Maharashtra. Thus, this was also a case under section 10, 13, 17, 18, 18A, 18B, 20, 21, 38, 39, 40, bracket 2 of the UAPA Act. This court in the earnest effort to draw a balance between the seriousness of the charge with the period of custody suffered and the likely period within which the trial would be expected to be completed, took note of the 5 years incarceration and over 200 witnesses left to be examined, and thus granted bail to the accused, notwithstanding section 43D5 of the UAPA Act. Similarly, in Sagar Patyaram Gorkhe versus State of Maharashtra, an accused under UAPA's unless on bail probably, had he been in jail for 4 years, and these were over 140 witnesses still to be examined. So similarly, I am also placed, my lord, and I am for the last 12 years I am in jail, and the witnesses who has
just 1 minute,
yes,
Mr. When was your client arrested?
Well, I prepared the list of the assemblies.
Yes, where is it?
Well, we'll give the copy. The FIR was lodged on 24/11/2001, 11, sorry, and appellant was arrested by the NIA on 11/6/2012. Well, I prepared the list. I'm sorry, I could not make a copy. Can you make 3 copies so that I can give one to him for correction? This is 1 copy. Kindly make photocopy. Acha, we are getting it, my lord. Actually, even then your lordship can have a look, my lord. I'll give a copy to him.
11/6/2011.
11/6. Compilation, I may go wrong.
No, but have you given him a copy?
But I am giving it, my lord. I've just said to make it, my lord.
So he has suffered incarceration for more than 12 years.
Lordship, it is.
And it is half the way, my lord. Half the way the trial. 100 more witnesses. 173 left. Only 170 as on today.
My instruction is that, Lordship, another 50-20 witnesses, those who are relevant, are to be examined. Not all this 100 and so on will be examined, and it should be over by mid of February or March. That is my instruction. I don't. But not 100 and so witnesses. That won't be.
On record, it is that.
It's there, of course.
What is the charge against him?
Lordship, he has been charged under 120B, 121, 121A, 420, 468, 471.
What is the allegation?
Of the Lordship, his allegation is, Lordship, he is amassing, Lordship, money by way of, Lordship, extortion. And there are also allegations of, Lordship, activities of, Lordship, ransom and killing, Lordship.
Ransom and killing.
He being, not he personally, the KCP, Lordship. Kangleipak Communist Party
list of this.
So the witnesses have, because your lordship, right now when your lordship is dealing with a bail petition, lordship will see what is there in the charge sheet and the with depositions of the witnesses given along with the charge sheet. So there it transpires, lordship, there are materials against you. I don't know whether those will be proved in the trial or not. But at this stage, your lordship has to restrict to the filing of the charge sheet and the statements that has been appended with the charge sheet before the.
We'll take it that he will be convicted. Even then, can you put someone into incarceration for 12 years during the pendency? Can you show me a judgment which has approved this? Any decision of the Supreme Court? Anything on this point?
I would be helped by only Gurvinder Singh at the moment, lordship.
Nothing else. Gurinder Singh is 2000.
That is 2000, and where it says it's not a matter of delay. It is what he has been charged. And my learned friend has relied upon Najib's case and subsequent case, and a submission has been made 3 judges bench. Whereas Gurvinder Singh was 2 judges bench. Now your lordship will consider, yes, it was a 2 judges bench, but then it is not a judgment per inquiry. The Honorable Court have the occasion to discuss the earlier judgments. It had the occasion to discuss the earlier judgments. It is not something that it has omitted K. Najib. It took into note the findings of K. Najib. And so far as the implications under UAP Act is concerned, lordship, the court has held over and over again. It is not that bail is the rule. Here, if there is a prima facie case, if the materials in the charge sheet and whatever has been placed before the court demonstrates that there is a prima facie case, there is no ground for a bail. That is my submission, lordship. He might be, lordship, he might come out
that
unscathed.
For every case. Every criminal trial, that will be true. What about that judgment where Supreme Court says more than 50% of the period of incarceration?
That would, in my humble submission, that would not apply in a special legislation so as the UAPA. That is a case where he might be accused of some other offense, but not under the special act.
What is the judgment to support your argument? That is correct. And there must be
So that has been discussed in Gurvinder as well, lordship. I'll come to it. If I may, lordship, in my lordship printout, it starts from paragraph 6.
That is the problem.
It starts with the source of power to grant bail. It is in the part of discussion and conclusions. If I may read, lordship, discussion and conclusion. We have heard the learned counsel on behalf of both the parties and have perused the records of the case. The present case involves the charges under UAP Act along with other charges under the IPC and Arms Act. Therefore, it is apt to consider the bail provision envisaged under Section 43D of the UAP Act before we delve to analyze the facts. Bail under UAP Act, Section 45D. In the course of the oral argument, both sides have laid great emphasis on the interpretation of Section 43D(5) of the 1967 Act. We'll begin our analysis with a discussion on the scope and limitation of bail under Section 43D(5) UAP Act. We shall extract Section 43D(5) for easy reference. And Section 43D(5) has been extracted. Thereafter, lordship, the source of power to grant bail in respect of non-bailable offences punishable with death or life imprisonment emanates from Section 439 CRPC. it can be noticed that section 43D5 of the UAP Act modifies the application of the general bail provision in respect of offences punishable under Chapter 4 and Chapter 5 of the UAP Act. A bare reading of subsection 5 of section 43D shows that apart from the fact that subsection 5 bars special court from releasing an accused on bail without affording the public prosecutor an opportunity of being heard on the application seeking release of the accused on bail, the proviso to subsection 5 of section 43D puts a complete embargo on the powers of the special courts to release an accused on bail. It lays down that if the court on perusal of the case diary or the report made under section 173 of the Code of Criminal Procedure is of the opinion that there are reasonable grounds for believing that the accusation against such person as regards commission of offense or offenses under Chapter 4 and or Chapter 6 of the UAP Act is prima facie true, such accused persons shall not be released on bail or on his own bond. It is interesting to note that there is no analogous provision traceable in any other statute to the one found in section 43D5 of the UAP Act. In that sense, the language of bail limitation adopted therein remains unique to the UAP Act. The conventional idea in bail jurisprudence vis-a-vis ordinary penal offenses that the discretion of the court must tilt in favor of the oft-quoted phrase, bail is the rule, jail is an exception, unless circumstances justify otherwise, do not find any place while dealing with bail applications under UAP Act. The exercise of general powers to grant bail under the UAP Act is severely restrictive in scope. The form of the words used in proviso to section 43D5 shall not be released, in contrast with the form of the words as found in section 437(1) CRPC may be released, suggests the intention of the legislature to make bail the exception and jail the rule. The courts are therefore burdened with a sensitive task on hand. In dealing with bail applications under UAP Act, the courts are merely examining if there is justification to reject bail. The justifications must be searched from the case diary and the final report submitted before the special court. The legislature has prescribed a low prima facie standard as a measure of degree of satisfaction to be recorded by court when scrutinizing the justifications materials on record. The standard can be contrasted with the standard of strong suspicion, which is used by courts while hearing applications for discharge. In fact, the Supreme Court in Zahur Ali Watari so-and-so has noticed this difference where it said, in any case, the degree of satisfaction to be recorded by the court for opining that there are reasonable grounds for believing that the accusations against the accused is prima facie true is lighter than the degree of satisfaction to be recorded for considering a discharge application or framing of charges in relation to offenses under the 1967 Act. In this background, the test for rejection of bail is quite plain. Bail must be rejected as a rule if, after hearing the public prosecutor and after perusing the final report or case diary, the court arrives at a conclusion that there are reasonable grounds for believing that the accusations are prima facie true. It is only if the test for rejection of bail is not satisfied that the courts would proceed to decide the bail application in accordance with the tripod test: flight, risk, influencing witness, tampering with evidence. This position is made clear by subsection 6 of section 43D, which lays down that restrictions on granting bail specified in subsection 5 are in addition to the restriction under the Code of Criminal Procedure or any other law for the time being in force or on grant of bail.
So, this judgment para 25 says there is a complete embargo on the power of special court to grant bail. But can you please explain how there is an embargo? Let us see
43D.
43D5 proviso.
Proviso said that it should be prima facie true. The allegation should be prima facie true.
That is right, but in the judgment is mentioned is a complete embargo.
No, my lord, it cannot be
Is
made.
that
Provided the court finds that it is not true, my lord. Complete embargo cannot be made. It will be like
Lordship,
taking away the legal rights.
let us read Lordship of 45
Yes.
D5 Lordship.
Yes.
Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and chapter 6 of this act shall, if in custody, be released on bail on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on perusal of the case diary or the report made under section 173D of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true.
Where is the complete embargo?
Lordship, I would agree with you, your lordship, on that. Although here what has happened is, lordship will remember, in Najib's case, since the court has said constitutional court, perhaps lordship that is followed. Because now what normal in practice, what happens is, lordship, I'll be very fair to your lordship. We were taught, go through the Bare Act first, then you give the citations, because the law is on the statute. Nowadays, things are the other way around.
What is it now?
Nowadays, you follow judgment of the Supreme Court, and what context it is delivered or what, that is immaterial. Statute comes in the end. Now, I would fully agree with your lordship. The statute does not make any mention about the constitutional court. It says court. It says court.
Any court.
No, it says court, but it is a natural, by a statute, the powers of the constitutional court cannot be restricted.
That is there.
It cannot be done even by amending the constitution.
Lordship.
Because right to remedies under Article 13 is a basic feature of the constitution. So it cannot be done even by amending the constitution, forget a statute.
Yes.
Therefore,
There is no
section
dispute on that, lordship.
43D
There is no dispute
had
on that,
nothing to
lordship.
do with power of the High Court or the Supreme Court to grant bail. If at all, these provisions apply to the special court. The Parliament cannot restrict the power of the High Court to examine issues coming within the domain of Article 21 or other fundamental rights. So that no argument is required on that. We are asking you that where is the complete bar even for the special court?
Here, for a moment, if your lordship will come to the definition of court in the lordship section 2 of this particular act, 2D.
Yes.
2D. That would be relevant, lordship, for purpose. If I may read, lordship.
Yes, please.
In this act, unless the context otherwise require, court means a criminal court having jurisdiction under the code to try offenses under this act, and includes a special court constituted under section 11 or under under section 22. 22 of the National Investigation Agency. Now, the code is also defined. With what code? Code is the CRPC, Lordship. So perhaps, Lordship, the interpretation of the Supreme Court with regard to the code here in the Najib's case or the case, Lordship, would be the trial court, taking into consideration that the code described in this act and the code referred to is the CRPC, and court says criminal court having jurisdiction. So since court is defined as the CRPC, therefore, Lordship, the other reading may be that it would be the trial court. In that view, if we look at the matter, Lordship, the trial court's decision is not wrong, Lordship.
All right. But you do agree that these provisions don't apply to the High Court and the Supreme Court?
No, Lordship. The constitutional courts. Similarly, Lordship, if this matters relating to Lordship granting sanctions under the Prevention of Corruption Act, although there is a mandate, there's a stipulation that the state has to give us sanction or a no objection for the CBI to conduct an inquiry. But then there's a Supreme Court decision in the case of West Bengal, so 2010, where the Supreme Court has clarified that this will not apply. Even if there is that in the Prevention of Corruption Act, it will not apply to the constitutional courts like the High Court.
Right. So on a maintainability issue, we are inclined to examine his application.
Yes,
You want to say anything on merit?
Lordship, there are materials which I will place with you.
You will. When?
No, Lordship.
I just know. You have the materials.
I have got, and the records are already there, Lordship.
You have filed your objection?
Yes,
long time. Because this bail petition is pending since 12.
Just one question.
Yes.
Why did you wait for 10 years before applying for bail?
My lord, I was trying in the trial court, my lord. Trial court has rejected me, my lord, and he was having family members to proceed to the High Court, my lord. So now they have.
No, trial court rejected in 2023.
Yes, my lord.
When did you file the
We have filed in on 12/12/23, my lord. We didn't time, my lord. Because 60 days is the filing of the appeal period, my lord.
No. You approached the trial court by filing the bail application in the year 2023, after 11 years of your.
No, earlier there was petition, my lord, because with new grounds come in, my lord, that's why we file in, my lord.
Earlier, your
Yes,
bail
yes, earlier that was rejected, we have not challenged it. Now we have challenged, because nowadays we can't directly come as a BA, my lord. This is to come through a criminal appeal, my lord. So certain
So
procedures.
the earlier orders of rejection are not under challenge?
No. You can't also, because it's time barred, my lord. 60 days is the lifespan, my lord, of an order to be challenged before.
Where are the earlier orders of rejection?
That your lordship will get it in the order, my lord, if the
Then
scan
we'll
copy
see
is
it
come.
next year. If you want us to figure.
Yeah, my lord, I'll get it, my
So
lord.
we'll say, come on, there is an issue here.
My lord, yeah.
Because we are hearing an appeal. Your similar prayers have been rejected by the court below.
Yes, my lord, earlier, my lord.
And you did not challenge, the last order you made, you came before the court.
Yes,
filing an
that
appeal.
is the cause of action I have arisen, my lord, in this
But if
appeal.
the earlier orders have been rejected, you have accepted.
No, we have
them.
stated, my lord, that is there, my lord, because now this our interlocutory order bail, though it has been nomenclatured as
See,
criminal appeal.
let us put things in perspective.
Sure, my lord.
It is no doubt correct that in a matter where liberty under Article 21 is
Enshrinement.
the constitutional courts will have a leaning. There's no doubt about it. But that doesn't mean we will overthrow the rules of procedure into the dustbin. We are not going to do it.
Sure, my lord.
This is not an application under 438 or 439.
Right.
It is an appeal. You are challenging an order passed by
Yes.
the court below.
Right.
You do not challenge the other orders, don't even bring it on record. And the last order which goes against you in similar application, you suddenly decide to challenge that and come to the court.
Absolutely.
So if we are to exercise our appellate jurisdiction, ultimately this is an appellate jurisdiction where, and the earlier orders are not under challenge. This might sound technical, but at least the orders have to be brought on record. We need to know what these orders are.
My only thing is that, my lord, actually the NIA prescribes, my lord, because this application is filed as an appeal, my lord, if your lordship will see my nomenclature of the filing of the petition. An application under section 21(4) of the National Investigation Agency Act against the impugn order. We have to challenge the order challenge.
Because the earlier similar orders rejecting bail to the petitioner has not been challenged, we deem it appropriate to hold that the present order has merged with the earlier orders, and therefore there is no scope for the appellate court to interfere with that order. That will be our order.
No, my lord, that will not
You have
be.
not challenged.
My lord, with all respect, my lord, because otherwise, if your lordship will see, my lord, the merit of the case, if your lordship just will like to take it on record, my lord, the honorable trial court has relied upon certain witnesses. Let us come to page 107, my lord.
Mr. Kamar, you have to give an answer to this question.
I'll give, my lord. Then
Tell me that I have not challenged. Suddenly I wake up and challenge. So ignore what has happened in the, because this is not 226 or 227. You are asking the court to exercise appellate jurisdiction.
That is true, my lord. But
Supposing you ask for an injunction, denied, rejected, again you ask rejected, suddenly you ask rejected, and then you say that I'll only challenge the last order. You show
my
us
lord, I have to
technically how-
challenge the last order because of the fact that I have to file it within the time frame. Earlier bail order, I have not preferred or selected to file
Correct, but
an
at least those
appeal.
will have to be brought on record.
That is there, my lord. Give me some time. By tomorrow or day after, I'll get it.
And what you have to say about this? Does it in any way act as an estoppel if you have not challenged the earlier orders?
There is no pleading on that, Lordship. At least he has to bring it on record. I'll contradict that. The fact that there has been no further development in the case, that is precisely the ground why the bail applications have been rejected.
This is a maybe, see, we are not trying to be technical, but these are issues we cannot completely ignore. At least we have to give a justification why it was not.
That delay has to be explained, Lordship.
It can't be that forget it. Earlier we
that
filed,
submission, my lord.
the court rejected,
No,
just
my
forget it. Let's focus on
My
the
lord,
present.
what is the procedure to file the bail application? Though the nomenclature may differ, it's an appeal under section 21 of the NIA Act.
Correct.
So we have followed that precise things.
I agree. I'm saying because
his submission.
because we
There
have
is
accepted the
delay.
earlier order,
There cannot be
we will
delay in bail
dismiss the appeal on that ground.
That is an appeal I filed on time. Only
Yes.
thing is that it would be better if those orders should have been annexed.
And you have to give an explanation why you did not challenge those.
Yes, my lord. That explanation is that there was nobody here. I am a native of Manipur, my lord. My wife and my husband both were behind the bar, so nobody was there to take step. Certainly, the wife was granted bail by your lordship's order at page 80. If your lordship will kindly have a turn on
Page
page 80.
You have to give us the handle to write a judgment.
Sure,
It can't
absolutely.
be
We'll give it.
ignored like this. This can't be ignored.
Page 80, your lordship, his wife Lakshmi Devi, my lord.
Hmm.
After 5 years of incarceration, my lord, she was granted bail by your lordship. Order dated 31/2023, my lord. In the same case, my lord.
All right, see the three things. First of all, we are finding it very difficult to understand. Can't say agree. Understand with the observations made in Gurinder Singh, where the Supreme Court has held that there is a complete embargo. But even if it is true, it is only for the special court. The fact remains that which is staring at the face, a person has been made to subject incarceration for 11 years as an under trial prisoner. That's a glaring fact we cannot ignore. But at the same time, we are exercising appellate jurisdiction here, which being a constitutional court, we will ultimately have our cord tied to the constitutional provision. But this is not a writ petition. This is an appeal. So we feel that he has to give some explanation on record, and we have to consider it after hearing you on that. Why the earlier orders were not assailed, and why this application was filed after 11 years of incarceration. What is there, we don't know.
Lordship,
He may have an explanation, he may not have.
Yes, yes.
His explanation may be accepted by the court, may not be.
I agree, Lordship.
And have you stated how many witnesses are yet to be examined?
My lord, actually, as the case progressed during these years, my lord, so we have given one statement at that time or the date of filing, my lord. That is at page on when we file a petition, my lord, at that
Page
time we
6.
have given it.
Paragraph 7, Lordship.
Diman Kolo?
Paragraph 7 of the.
7. At that time, it was 97, my lord. And now it is 117. That the appellant humbly states that till date, only 97 PWs out of the total 217 PWs have been examined in the instant case. However, no evidence material has come.
Mr. Kamar, have you understood the point?
Yes, yes, sure, ma'am. I'll take care of it, ma'am.
How
Just
much
give me
time will
some
it take? How
2-3
much
days,
time
my
will
lord.
it
I'll
take?
file
Because
it.
these are matters we don't want it to be pending for long.
My lord, we have to procure the certified copy, my
Correct.
lord. Because actually, there's none to take step. The wife, after getting bail, is taking care of the child's education and all these things, my lord. They are minor, my lord. So this man is only left now at the large of the.
That we understand,
Yes,
but then
We'll do it, my lord.
proceeding has
We'll
to
do it,
be.
my lord, within 2-3 days.
How
my
much time in it? 1 week?
lord. On Friday, we'll file it, my lord.
1 week?
On Friday, my lord.
List in the next week, so as to enable Mr. Jet Kamar. This bench will continue,
Yes.
but you may still get a rejection order. Don't worry.
Whatever order, my lord. Whatever order, my lord.
On the request of Mr. Z. Kamal and his senior counsel appearing for the appellant, this matter is directed to be listed again in the next week, so as to enable him to file an additional affidavit, bringing certain documents, relevant documents on record, along with supportive pleadings. Mr. RKD Chaudhary, learned DSGY, to, in the meantime, obtain instruction and produce written instruction before this court on the next date, indicating the number of witnesses that the prosecution intends to examine in this case and the probable time period that will be consumed in doing so. List this case accordingly.
My lord.
You get us both these things, and Mr. Kamar, there is a judgment,
My lord.
I think authored by Justice Sanjay Kishan Kaul, as his lordship was then,
My lord.
where it has been held that incarceration periods, how it is to be examined and what could be the maximum. And that is all examined in the provision of, in the light of provision of the CRPC,
Yes, my lord.
but with a overarching consideration of Article
I have got
21.
it. But in this case, my lord, I think it will not apply because of the fact, my lord, those
Those are under CRPC.
yes, my lord, that's why, my lord, I have not cited it.
All right. Next
Now,
week,
only one thing, my lord, I would just like to point out for academic also, my lord. Now, my lord, these materials, that there are sufficient materials against the accused. These are materials which they have collected during the investigation, that is 161. Now, it has been translated into evidence while during trial. So what has come, it is to be seen. But the trial court has rejected that it cannot be seen. But we have relied upon a good judgment from this Honorable Guwahati High Court, my lord. What will be the test then? Whether 161 will prevail or the evidence? So that way also the trial court has not.
yeah, that we agree, because he can't be left remediless like
Yes,
this. Trial court says we'll not agree, we'll not examine. The High Court will say, sorry, the trial is going on. Personal, that cannot
That,
be the intent.
that
of
is the one thing, my lord.
That will be a total,
Mismatch, my
it can't be. Constitutional safeguards cannot be taken away.
correct. Absolutely.
Huh.
No question.
But the courts will have to act in a responsible manner, see what is the allegation, what are the circumstances, what is the evidence. In some cases, it may not actually be bona fide be possible to conclude an investigation within a time frame.
My lord, there are
Courts will
observations
have
from the Honorable Supreme Court, my lord. UAPA is not that stringent than the NDPS. Because why I say, in NDPS, the prima facie consideration is that the allegation must be, he must be guilty and here the prima facie true. So it is less than my NDPS said. But NDPS, like, people are also getting bail, man.
No, that's true.
That
Bail-
observation is
bail-
also there. Maintain as
There
it
can't
is.
be a complete no. And you please get instructions.
Yes, yes, Lordship.
We are going to seriously consider his bail application on the
Right.
next day. Please be clear about it.
So it will be also good for the trial court, then they will go by those parameters. That's
So,
all.
this is more to give an opportunity to you also to examine and make deeper submissions if you want. All right, next matter.
Much obliged, my lord.
Binding matter, item 21.
This is the last.
Liability loss.
Hmm.
Lord, against acquittal lordship. Appeal against acquittal loss.
Appeal against acquittal.
Lordship. My lord, 15 years son of the my lord appellant was my lord killed. My lord,
Hmm. All right.
one was declared accused, one accused was declared my lord juvenile. Against other lordship, the appellant has prepared this appeal lordship. Is Mir Hussain. He has been acquitted lordship. PW.
Which part of the judgment you are aggrieved?
My lord, only my lord against acquittal lordship. The PW5 and PW1
No. Which part of the judgment are you aggrieved with?
against acquittal of the appellant private respondent lordship.
Mr. Ahmed, please answer the question. Which part of the judgment you are aggrieved with?
Yes.
Which part of the observation of the judgment you think is illegal?
My lord, paragraph 24 lordship. Paragraph page 24, paragraph 26 lordship.
Hmm.
Onwards lordship, the evidence has been evaluated lordship. Paragraph 26, page 24 lordship. From the evidence of lordship.
Hmm.
And the paragraph 20, page 25, it is stated that none of the witnesses have stated before him that they saw accused Mir Hussain assaulting the deceased. My lord, the
Hmm. Yes.
this is the IO, my lord, this is the IO's statement, lordship. Other witnesses stated, my lord,
Hmm.
during deposition also, lordship, that they have seen. PW1, the informant has stated clearly, lordship. PW4, mother, my lord, PW2 and 3, although my lord, the evidence is very short, but there is specific cross against that, no cross-examination was there, lordship. The accused juvenile, my lord, I have nothing to say against juvenile lordship. He was absconding lordship. Now,
Lordship, somebody must represent the petitioner, Lordship, because he is on for acquittal, Lordship.
So there, nobody is there.
Nobody is there because he will have to be heard, Lordship. Notice করেছিলেন?
Notice has been issued.
notice was lordship.
Says none
Issued
appears
lordship.
to the respondent despite service of notice.
PW1, my lord, is at page 7, lordship. My lord, 1, 2, 3, lordship, clear, lordship. Short evidence, lordship, but they have seen, lordship. Not crossed, my lord. Examination, cross-examination was not there.
So what do we do? He is not appeared despite service of notice.
Yes, lordship, against, my lord.
Or should we engage a legal aid
Yeah,
counsel?
he must be given a chance, Lordship,
He has not yet done.
because
No, the state has not preferred appeal. Public prosecutor has to defend this judgment. What is to be done? Should we appoint a amicus? or-
Lemacus may be appointed, Lordship.
That may be done, lordship.
Or Lemacus may be appointed because,
My lord, he has chosen not to appear, lordship.
but it's for acquittal, he'll have to appear.
His version has to be known. Anyway, I heard Mr. M.H. Learned counsel for the petitioner. Also heard Ms. A. Begum, learned APP Assam appearing for the state. None has appeared for the respondent number 2 despite service of notice. This appeal is against the judgment and order of acquittal. Full stop. Therefore, we are of the opinion that although the respondent number 2 has chosen not to appear despite receipt of notice, his interest should be represented by an amicus curiae so as to assist the court in the matter. Stop. We accordingly direct the registry to assign this brief to an amicus curiae from the panel, from the existing panel, so as to represent the respondent number 2. Copy of the paper book and other relevant documents be furnished to the learned amicus curiae. List again in the first week of January 2025. Second week of January 2025.
Lots.
By reflecting the name of the learned amicus curiae in the cause list. Let somebody be present, then otherwise again there is a.
Lordship, Lordship.
That is over, list is over.